Hello, my name is Tia Rodriguez. I'm going to talk about crime victim policies. During the last 2 decades, federal and state governments have significantly broadened the rights of crime victims. There have been national crime victimization surveys documenting high levels of crime, but yet low levels that are reported by the victim. This is one limitation of data collections. With surveys like UCR and NCVS, the victim is referred as an anonymous victim, therefore may feel more comfortable giving out their victimization encounters as opposed to reporting to the police. The Uniform Crime Report, although it does not provide detailed information on crime victims and doesn't cover a wide range of crimes that do occur. The National Crime Victimization Survey also comes with limitations. This report depends on victims to accurately report their victimization. It also just interviews with victims that live in households, therefore excluding persons in prison and homeless people. In 1982, the Victim Witness Protection Act was created as a part of the Victims' Rights Beginning. This act authorized victim restitution and the use of victim impact statements in federal court. It also requires the attorney assigned general to issue guidelines for the development of further policies regarding victims and witnesses of crimes. By 2004, the Victim Rights Act was born. Victims of crime were given significantly increased rights, including the right to be present on federal courts and heard at public court proceedings involving release, plea, sentencing, or parole. Another thing that hinders victim rights is that every state differs their idea on who is eligible for their rights, with some states limiting rights only to those who are a victim of violent felonies. Although the states also differ in the types of rights provided. A study was conducted at the Vera Institute that analyzed victim rights legislation for every state and they coded it by using a standardized evaluation form. The study showed that rights to compensation, notification of court appearances, and the submission of a victim impact statement before sentencing were provided in all 50 states. A good portion of the states also gave victims the right to restitution, to attend sentencing hearings, and the right to consult with officials before offers of pleas or release of defendants from custody. One of the big challenges of the victim rights activists is that the criminal justice systems don't honor these rights. Because of this, some states began to develop state-level victim services offices that serve as oversight agencies that monitor compliance and center for referrals and links to victim service organizations. Still, a 1998 survey noted that even states with strong victim rights legislation, many are still not notified about key hearings and proceedings. I think this to be unethical because the victim deserves the right to know the details of the court case and the offender. The victim is a part of the victimization situation and can provide insight on what happened. Knowing whether the offender is behind bars could ease the victim and provide closure. It could help the victim feel more secure. In 1982, California was the first state to pass a constitutional amendment enumerating crime victim rights that include the right to public safety. 32 states have adopted constitutional amendments consisting of victim rights. This takes an advantage because courts have honored rights contained in constitutional amendments. The fight of secure rights for crime victims has been a long and unbalanced battle. To protect the rights of victims, new approaches have been established. Constitutional amendments help rights more enforced. Compliance programs and clinics were made to ensure victims are able to exercise their rights in different ways. These include training of criminal justice officials and filing complaints against agencies who've denied crime victims their rights. Thank you.